Good morning. Today is August 6th. It's 9 a.m. This is a Commissioner's Weekly Meeting. Eric Blank, Commissioner Gilman, preliminary remarks, or are you ready to approve the consent agenda as presented?
Good morning, and I would vote to approve the consent agenda.
Commissioner Plant.
Good morning. I would approve the consent agenda as well.
As would I. Let's go to Dr. Fishaber and Ms. Harper. I see 4 rare-related rulemakings. Walk us through however you'd like. Dr. Fishaber.
Good morning, Commissioners. Pam Fishaber with Deputy Director of Public Safety. With your permission, I would like to take items 1 and 4 and discuss those together, and then 2 and 3.
Good.
So this morning, Senate Bill 25-052 went into effect, which changes the confidentiality requirements that were codified in 40-18-104 CRS. The statute was changed so that commission reports go from being confidential to having final commission reports being publicly available. The legislation did allow that the commission can keep the reports confidential while they're in the process of investigating and reviewing. And then upon commission approval, those reports would be publicly available. Do you have any questions?
I don't. Commissioner Gilman?
No questions.
Commissioner Plant?
No, I don't. Thanks.
Keep going.
Okay, so for item number 1, the recommendation would be to open a notice of proposed rulemaking to enact the new statute change at 104. And then item 4 would be to put the rule into to initiate.
Tough morning.
Oh, well, to have a temporary rule for the confidentiality rules.
Commissioner Gilman?
I agree.
Commissioner Plant?
I also agree.
As do I, and that can be an ABC decision opening both proceedings, and for the one issuing a NOPR and referring it to an ALJ, and the second can be issuing the temporary rules. So did I get that right, Dr. Fishaber?
You did.
I have help.
So then items 2 and 3, this morning as well, House Bill 25-1110 went into effect, which requires the commission to change the rules on how cost allocation for crossing surface replacement and maintenance is performed. The rules currently require all road authorities and railroads to split those costs 50-50. Under the new legislation, CDOT would remain splitting 50-50 with the railroads for any crossings on their roadways. But for the remainder of the local governments, it would change to the railroads being responsible for all the costs associated from the end of tie to end of tie. So that would be things like the surface, the rail, the ballast, the ties, and then the local governments would be responsible for paving up to the end of ties. And if you don't have any questions, I will make a couple recommendations.
Yeah, if you can make your recommendations, and then we'll come back with questions, comments, or a vote.
Staff would recommend that the commission open a notice of proposed rulemaking to make the changes as required by House Bill 25-1110. And for item number 3, staff recommends that a temporary rule be put in place to put this new law into effect today.
Isn't number 2 the temporary rule?
Oh, yep, sorry. Switch those. 2 is the temporary rule, 3's.
I'm just trying to prove I'm awake.
Not.
Commissioner Gilman?
Thanks, Dr. Fishaber. I agree.
Commissioner Plant?
I agree also.
And again, those can be an ABC decision, opening proceedings, issuing temporary rules, and for the third one, issuing a NOPR and referring it to an ALJ. So thank you, Dr. Fishaber.
Thank you, Commissioners.
Proceeding number 21A-0141E. Back to 2021 ERP. My head already hurts, Mr. Eden.
Yes. Good morning, Commissioners. I'm Michael Eden with your advisory team. On July 15th, 2025, Public Service Company of Colorado filed a motion to initiate Stage 2 pricing relief process with a motion. The company requests the Commission authorize the initiation of Stage 2 price relief as contemplated by decision number C25-0024, issued January 14th of this year. I'll refer to this as the CEP delivery decision. Before I get to the substance of the motion, I'll provide some context for what the Stage 2 price relief mechanism is. In the CEP delivery decision, the Commission approved, among other things, a process by which developers could seek price relief based on changes of federal law. This Stage 2 process was intended to encourage developers to move forward with projects, even though future tariffs or changes to tax credits might impact the project's financials. As proposed, the Stage 2 process would be initiated by a motion filed by the company, staff, or by the Commission on its own motion, describing the change in law and explaining why Stage 2 relief is appropriate. After considering any responses to the motion for Stage 2 activation, the Commission would determine whether to initiate a Stage 2 relief process. Bidders would be required to submit requests and documentation to the Independent Auditor, or IA, within 30 days of any Commission decision approving Stage 2 relief. After the IA makes its verification, it would then submit all materials to the Commission. Interveners would have 21 days to review the IA's initial determination, and Public Service and any impacted developers would then have 7 days to file response comments. Ultimately, the IA's determination regarding the price relief would not go into effect until the Commission's decision. Stage 2 relief would provide up to a 15% total price increase, inclusive of any approved increase in Stage 1. So turning now to the motion before you, in the motion to initiate Stage 2 price relief, Public Service asserts that numerous new tariff actions have been announced since the CEP delivery decision. Public Service further notes the reconciliation bill that Congress passed on July 3rd, 2025, that advances the expiration of tax credits for certain renewable projects. The company also references the recent executive order requiring the IRS to review the guidance related to qualifying for the renewable energy tax credits. For administrative efficiency, the company asks that Stage 2 relief be available to any and all developers pursuant to the Commission-approved process set forth in the CEP delivery decision. Regarding conferral, Public Service represents that independent power producer trade associations support the motion, and no party that responded to the conferral has expressed opposition. I'll further note that we have not received any responses to the motion, and the deadline for responses has now passed. I'll stop here for any questions or your discussion, or I also have a recommendation.
Yeah, maybe I'll share some thoughts and then see where my colleagues are. So for me, I'm prepared to grant the motion and initiate the Stage 2 process now. With all the uncertainties that have developed this past year, I think we need to be as fast and flexible as possible. And I'm glad we have this process and contract language in place. Although it's obviously not in this record, I think the governor's recent letter on prioritizing the deployment of affordable clean energy aligns with the Stage 2 process we're hopefully implementing today. In addition, I'd also approve the company's request that Stage 2 relief be available to all developers, regardless of whether they've formally notified the company that they need Stage 2 price relief. I'd also note that there's a 30-day deadline for bidders to submit requests and documentation to the IA that may be perhaps too aggressive, given that there is some expectation that the Treasury Secretary may release additional beginning of construction tax credit guidance on August 18th. I just offer to the company and bidders that we'd be flexible on the 30-day deadline as appropriate and requested. In addition, several parties in the other ongoing ERP proceeding, the JTS, as well as the governor's letter, have suggested that the passage of the reconciliation bill and the promulgation of a series of executive orders by the administration may create additional urgency to provide greater regulatory certainty to help bidders qualify for tax credits. Given this reality, I'd be open to offering both the 2021 ERP backup and supplemental bids, the same stage 2 pricing and other timing relief, if it could help us get timely access to additional cost-effective projects that could be built within the 15% stage 2 price relief cap. So without maybe deciding that now, I'd at least make that invitation to the companies and the parties. Finally, depending on where you guys come out, it might make sense to ask the company to reach out to the relevant developers, as they may not be aware of the stage 2 price relief process and the flexible stance that perhaps we're going to take. So Commissioner Goen, thoughts, comments, anywhere you'd like to go?
Yeah, thanks. Well, thanks, Mr. Eden, and appreciate your comments, Chair, and really largely agree with them. At this point, I don't think we have any choice but to start the stage 2 price relief. And just to not be talking in code, price relief means price increases.
Yeah.
Because of, I know we use what it's been called, but this is a direct consequence of a lot of these federal actions that the bidders are really having a lot of trouble with figuring out how to price their projects. And it's quite evident that all of these projects look to need increased pricing as a direct result of these things. So certainly would not be our first choice, I think, for ratepayers in terms of what they'll be paying for these eventual resources. But as you pointed out, given kind of some of the really dramatic tax changes, there is increased urgency, even if it comes at a somewhat higher price, to ensure that we can secure as much of that funding as possible for these projects and move as expediently as possible. But that in and of itself also entails likely price increases, which is very unfortunate, certainly something we would have liked to avoid, but I certainly see why, especially the federal circumstances, have left these bidders with no choice but to begin this process. So I'm fine with the different specifics that you articulated as well.
I appreciate it, and just say it's also a result of the delay. It's just so frustrating that we couldn't see these projects be online now and not subject to all this.
Right.
So-
I think that's a fair point. Like, the policies aside, the uncertainty in and of itself has caused some paralysis, I think, among bidders, among the company, which in and of itself is costly, which is too bad.
Sorry, Commissioner Plant.
Yeah, no, I appreciate the comments and agree with your approach, Mr. Chairman. It seems maybe a little strange to say in a 2021 proceeding that time is of the essence, but it really is. Yeah, this is a very uncertain time, and I think the quicker we can resolve these issues, the more benefit it'll be to the ratepayers. But I don't think we should sort of gloss over the fact that these federal changes are going to lead to higher costs, and it's at this point somewhat unavoidable.
All right, does that give you what you need? Are you guys okay if we do an ABC decision here? I see both colleagues nodding.
Yeah.
So, Mr. Eden, does that give you what you need?
Yes, we can start working on that AB decision right away.
Thank you, Mr. Eden. And I'm going to take up 24A-0442E at the end and go to 25A-0281G. Mr. Davis, Gaz Pim.
Good morning, Commissioners. On June 30th, Public Service Company of Colorado filed an application to implement what is called a Gas Performance Incentive Mechanism, or GPIM. Recall that a GPIM was a concept developed through a gas cost adjustment, or GCA, rulemaking following the enactment of Senate Bill 23291. Rule 4607B requires Public Service to file an application for a GPIM with the following minimum components. There would be a GPIM actual gas rate for a completed calendar quarter. There'd be a GPIM benchmark rate, which is a measure of the total gas cost GCA for similar quarters in the previous 3 years. And there would be a GPIM sharing amount calculated as 4% of the dollar difference between recent purchases at the actual GPIM rate and the benchmark GPIM rate, with that difference being either positive or negative. The GPIM sharing amount would have a deadband and would be subject to a cap. Consistent with Senate Bill 291 and the new GCA rules, the GPIM proposed by Public Service through its application is intended to share gas commodity costs between the company and its customers based on an established set of factors and conditions. Much of the company's direct testimony is focused on exclusions of certain categories of gas costs from that calculation of a gas cost differential. The company requests that the Commission approve a 12-month rolling annual cap of $6.5 million for the GPIM, subject to sharing parameters specified in the filing. Public Service further requests the Commission approve that any sharing penalties be offset against accrued interest on over-recoveries of the gas GCA deferred account during the same period. Notices of intervention of right were filed by trial staff of the Commission and the Utility Consumer Advocate Office. Both request a hearing. Trial staff seeks to examine the criterion used in the calculation of the GPIM, whether the proposed GPIM aligns with the Commission's rules, and the potential financial impacts of the GPIM on ratepayers. And in its intervention pleading, UCA highlights 2 areas of potential inquiry. 1, whether the proposed cost and quantity exclusions are in the public interest, and 2, whether the use of interest payable to ratepayers from the deferred account should be used to offset any penalty. I can provide a recommendation if you'd like. The question before you is whether to set the matter for hearing.
Yeah, if you have a recommendation, that'd be great, Mr. Davis.
I recommend that the Commission deem the application complete and refer the matter, including the interventions, to administrative law judge by minute entry. At a high level, Public Service's proposed GPIM appears to align with the principal requirements of the new GCA rules, and based on the intervention pleadings, the case will likely encompass primarily a technical review and a policy review of the details of the proposed GPIM's construct put forward by Public Service.
Commissioner Goen.
Thanks, Mr. Davis. I agree.
Commissioner Plant.
I also agree.
As do I. Thank you, Mr. Davis. 25A-0284G, CNG 2026-27 DSM plan. Mr. Davis.
Yes, and for this next item, the Commission will decide whether to set for hearing the application for approval of a 2026 to 2027 demand-side management plan filed by Colorado Natural Gas. CNG explains that its plan follows proceeding number 23A-218G, where the Commission addressed both CNG's 2024 to 2025 DSM plan and its more encompassing 2024 through 2027 DSM strategic issues. This 2026 to 2027 plan addresses energy efficient targets, a DSM bonus structure, and other aspects of CNG's DSM programs. CNG explains that its proposals largely continue the terms of the Commission-approved Comprehensive Joint Settlement Agreement in that earlier proceeding. That is, the DSM plan continues CNG's 5 natural gas efficiency programs, including the Residential Energy Audit Program, the Equipment Rebate Program, the Income Qualified Program, Energy Efficiency Kits Program, and the Commercial and Industrial Program. CNG seeks continued flexibility to add new programs, to reduce or increase rebate levels, to adopt new or discontinue existing measures, or change technical assumptions or eligibility requirements during the term of the plan. CNG states that in accordance with the Commission's rules, CNG will ensure at least 15% of program expenditures are directed to improve energy efficiency in income-qualified households. CNG filed the application without supporting testimony. Notices of intervention of right were filed by trial staff and UCA. Both request a hearing on the application. In general, they both seek to ensure that the commission conducts a thorough review of CNG's filing. So I can provide a recommendation for this case also if you'd like.
That'd be great.
I recommend that the commission deem this application complete and refer the matter to an administrative law judge by minute entry.
Commissioner Goman,
I agree.
Commissioner Plant,
I also agree.
as do I. Thank you, Mr. Davis. Greatly
Thank you.
appreciate it. Proceeding number 25D0328G, Ms. Harper, Rocky Mountain Natural Gas CNG for compressor replacement.
Good morning, Commissioners. Ruthie Harper of your Commission Council. Before you today is whether to accept a petition for declaratory order filed by Rocky Mountain Natural Gas, or RMNG. RMNG requests a declaratory order finding that no certificate of public convenience and necessity is required to replace two compressors located at its Crystal River compressor station site, which is located in Garfield County, with one new compressor. RMNG asserts that no CPCN is required because the new compressor is an equivalent replacement rather than an expansion of facilities, and therefore is considered ordinary course of business. RMNG explains that it only filed the petition because of the settlement that was reached in prior proceeding number 17 AL 0654G, where RMNG had agreed to file either an application for a CPCN or a petition for a declaratory order, that none was needed, unless and until the commission promulgates rules or establishes a definite policy regarding whether and under what circumstances a CPCN is required for a gas utility to construct a new compressor. Further, RMNG asserts that time is of the essence and therefore requests the commission set a shortened 4-day response time to the petition and rule expeditiously on the merits. I can pause for questions or proceed to my recommendation.
No, if you can go to your recommendation, that'd be great.
I recommend that the commission accept the petition, issue notice of the petition, establish a 14-day notice and intervention period, and refer the matter to an administrative law judge for disposition, including the establishment of a procedural schedule and any filing dates for further briefing. And that could all be done by one order today.
Commissioner Gilman,
Yes, I agree.
Commissioner Plant,
I agree.
as do I, and that can be an ABC order as you suggest, Ms. Harper. So thank you. Let's go back up to proceeding number 24A-0442E. Mr. Eden, Ms. McLaughlin, and Mr. Mendelson. Take us
Yes.
away.
Good morning, Commissioners. I'm still Michael Eden with your advisory team, and I'll be joined for this one with fellow advisor Mike Mendelson. This morning, we'll kickstart the deliberations in Public Service Company of Colorado's Just Transition Solicitation, or JTS. Before I set the context for your deliberations, however, I'll turn it over to Assistant Attorney General Mitch DeCenzo to address a motion to strike that was filed earlier this week.
Thank you, Mr. Eden. Good morning, Commissioners. Mitchell DeCenzo of your Commission Council. On August 4th, 2025, Moffett County and the City of Craig filed a motion to strike a portion of Pueblo Intervenor's statement of position. The statement in question, contained in Pueblo Intervenor's SOP, asserts that Moffett and Craig's cross-enter testimony claims that employee impact payment should go to Moffett and Craig as opposed to Hayden and Routt County, and that the local governments have been quote-unquote fighting about who should receive the payments. The motion to strike contends this statement is false, argues alleged facts not in evidence, and is advanced for improper use. The motion to strike requests that the statement be stricken from the record because Moffett and Craig did not file cross-answer testimony in this proceeding. There is no evidence in the record that Craig's request for community assistance has been made in lieu of or as opposed to the Routt County governments. and evidence does not show that the governments have been fighting but have been supportive of each other throughout the proceeding. The Routt County governments support the motion and add that they are not fighting with Moffett and Craig and support the right of all coal transition communities to advocate for their own transition needs. Pueblo interveners opposed the motion, and all other parties either take no position or did not respond to conferral. The motion to strike requests that the commission set a shortened response time of Monday, August 11th, 2025. And I can pause here and proceed to offer a recommendation.
If you can give us a recommendation, that'd be great.
At this point, Council recommends setting a shortened response time to Monday, August 11th, 2025, as requested in the motion to strike, and addressing the substance of the motion at a later date.
Commissioner Gilman,
I agree.
Commissioner Plant,
I agree.
as do I.
Okay, and I think this can be done through a ABC order.
Absolutely.
Thank you.
Mr. Eden.
Right, thank you. So for the benefit of the listening public, I'll start with some brief background of this proceeding. The concept of the JTS first appeared in the updated, non-unanimous partial settlement agreement that Public Service filed in the 2021 Electric Resource Plan and Clean Energy Plan, or ERP-CEP. The JTS concept dovetails with the retirement date of the Pueblo Unit 3 coal facility. One of the primary objectives of the JTS is to acquire utility generation and storage resources for the next several years, which will have significant impact on emissions reductions, ensuring a just transition to those communities most impacted by the company's retirement of its coal fleet, and long-term rates. The deliberations that will begin today will be memorialized in the Commission's Phase 1 decision and will include setting assumptions about how much electricity demand is anticipated to grow in the next several years, how to proceed with proposals to build additional transmission, ensuring a just transition for coal transition communities, and numerous other issues that impact Phase 2 of this proceeding. In Phase 2, the Commission will ultimately approve, modify, or reject the company's plan to acquire a portfolio of generation and storage resources. To set it another way, in Phase 1, the Commission sets the key inputs and assumptions that will determine how Public Service will conduct a competitive bidding process and organize the best bids into Phase 2 resource portfolios. In Phase 2, the Commission will evaluate various resource portfolios and determine whether the utility is entitled to a presumption of prudence for pursuing a particular resource portfolio. During the course of this Phase 1, the Commission received numerous public comments. Many of the comments were emailed to the Commission, but we also received a fax and a voice message. We even received one petition with over 2,000 signatures on it. All of these have been uploaded into the e-filings and collected for your consideration. And then in addition, I'd note that the Commission held 4 public comment hearings during this Phase 1. I'll talk more about the various public comments we've received in future deliberations, but I want to turn now to the primary issues advisors will tee up for your discussion this morning: the load forecast, or the future electricity demand, and the Phase 2 framework, or supply side flexibility. Advisors recommend the Commission consider these 2 fundamental issues together for several reasons. Starting with load forecast, Public Service predicts that it will have a very significant growth in load over the coming years. The vast majority of this projected load growth is expected to come from new large loads, such as data centers, increased adoption of electric vehicles, or EVs, and growth in beneficial electrification, or BE. The company's load forecast is a critical driver of the amount of resources it will need to acquire in Phase 2, has significant implications for customer rates, and is an issue that parties have extensively litigated throughout this proceeding. This brings me to the Phase 2 framework, which, as proposed, is intended to help account for the various uncertainties in future load growth by introducing supply-side flexibilities into the ERP process. For instance, the Phase 2 framework contains the concept of an incremental need pool, or INP. Under the INP, various backup bids will be provided option payments in exchange for remaining available to the company should an approved project fail, or if a new large load that wasn't included in the initial load forecast materializes. The Phase 2 framework also includes a second solicitation of resources in 2027. This supplemental request for proposals, or RFP, would primarily aim to acquire resources for 2032 and 2033. Importantly, the supplemental RFP would use an updated load forecast that can adjust to certain changes. While there are other components of the Phase 2 framework, such as transmission filings, I suggest focusing on the INP and supplemental RFP for today. And then finally, another proposed tool to increase supply side flexibility is the Strategic Resilience Reserve Fund, or the SRF. The SRF is a $500 million fund designed to allow the company to acquire long lead time components like combustion turbines, or CTs, transformers, and breakers. The company argues the SRF will allow it to reserve critical equipment and prevent supply chain issues from unnecessarily slowing down necessary resource investment. Mr. Mendelson and I are prepared to get into the details of the various issues regarding load forecast and the Phase 2 framework, but I'll turn it over to the Commission first for any initial thoughts and direction.
Thank you, Mr. Eden, for framing it and for working with the commissioners to package this in a way that recognizes the interrelationship among the issues. So I just want to start out saying that I think these deliberations will take multiple iterations. My hope is that advisors can walk us through some preliminary issues today, including load forecasting and the overall Phase 2 framework. And as such, I view this as the beginning of our conversation, such that many critical details may not be addressed until future deliberations. For me, the primary feature of this case and record is the considerable uncertainty given the rapidly changing economic and policy environment. From this perspective, some key unresolved uncertainties involve whether existing customer tariffs provide sufficient revenue to offset the actual costs of serving new load, particularly given rising supply costs, understanding future transmission needs and how they're impacted by the amount and location of new load growth, lack of clarity about the environmental impact of new load growth given evolving federal policy, the probability that new revenue actually materializes given sales forecasts that are up to 40 times greater than historical experience, and the recent large shifts in the company's large new load pipeline. And finally, 5, curtailment risk. And all this uncertainty is playing out in the context of major delays and cost increases for the 2021 ERP projects. So given all these uncertainties, I can't get comfortable approving anything like the level of resource need and investment that the company is seeking in either of its base load forecasts. As such, I want to propose a lower demand forecast and a smaller resource need to give us better time to better maintain affordability, address environmental impacts, and resolve key uncertainties. So my starting point for the load forecast is the low load. And even then, I have some significant downward adjustments to suggest to the EV and clean heat plan components of that forecast. Overall, I'm looking more at a final resource need in the 4,000 to 5,000 megawatt range, and not the 6,000 to 7,000 megawatt range in the company's low load scenario, and certainly not the 8,000 to 12,000 megawatts in the company base cases. At the same time, for me, there is so much uncertainty right now that I think we need to approach this decision with humility and prepare for the real possibility that demand growth could be significantly higher. From this perspective, I strongly support much of the company's proposals to create supply flexibility through multiple RFPs, an interim resource need pool, and the Strategic Resilience Reserve Fund, although I do have some material modifications to suggest on those approaches. So I'd move forward into the initial RFP with a substantially reduced load and resource need forecast. But at the same time, my willingness to do that is contingent on investing in considerable supply side flexibility to create optionality. So I guess I've sort of asked advisors to tee up some broad discussion areas for deliberation because of the way these issues interrelate. Instead of going through each element of the load forecast one by one with a summary of the parties, I'd like to hear how you guys think about it And for me, my ability to reduce the low load forecast is critically contingent on being able to invest in supply side flexibility. So for me, the two are just linked together. So I've tried to work with advisors to structure the deliberation in a way that get all these pieces on the table and are thinking out. And then we can see where we land. So that's my thoughts, Commissioner. Go anywhere you'd like to go. And if you'd like to take the issues piece by piece, that's fine too. So anywhere you'd like to go.
Yeah, good morning. It will probably make sense to talk about some of them in more detail, but happy to start with kind of like some more general thoughts. Well, this is a huge proceeding, and I remember the prior ERP, right, the 2021 ERP that is still going and ironically appeared on this agenda as like that was at the time the largest case public service company had ever filed, and this one really dwarfs that case quite a bit. So, you know, especially given some of the issues we even talked about in that stage 2 price relief. I mean, this is such a difficult time to be getting into all of this. We're seeing rapidly escalating costs of our generation sources, of needs for transmission. We're still in the midst of a transition in our resource mix and grappling with, you know, how to technically recognize those features and ensure that both on the demand and supply side, we're properly kind of allocating factors for different resources to understand how this will also play out. And then, of course, we have this really massive load forecast that I think you well articulated as far in excess of what we've seen on the system. Not to say it can't happen, but clearly this sets up, you know, really a very difficult task with this dramatic difference in forecast from past experiences. And so while, you know, my priority is to ensure we're strategic and supportive of that load growth, whether it be for certain large loads or electrification to meet other state policy objectives, it's very important that we ensure that that support should not come at the cost or undue risk to existing ratepayers. And so that's really the balance we're trying, I think, to strike here, is to figure out, you know, what is the most likely path, and then how do we ensure that we can really minimize that risk, both economic and technical, for the other customers. And so I tend to agree with you, just like directionally, is that the vast majority of that forecast is far but certain, right? And so how do we parse out what is the most likely or kind of safest bet load forecast going forward that seems the best supported in the record to ensure that really is going to show up? And then for the rest, that is less certain, more speculative, or requires several pieces to fit together for it to pan out, you know, how do we ensure that our processes going forward are flexible enough to kind of more quickly than in the past be able to respond to and be ready to serve that load, so long as that load actually has some certainty and financial responsibility to the system. So in general, I agree with you that, like, we've been presented in this proceeding several tools that may be able to speed up that process or provide a more iterative process to better respond. I mean, even as we saw in the base forecast from the direct case to the rebuttal case, a massive change in the expected load. And so that is kind of case in point that this is a very uncertain time. And so I think we can look at some of those tools that have been presented here to figure out how do we right-size the forecast for what seems like the most likely and least risky at this point, but then also be able to deploy these tools to, in a responsible way, you know, respond quicker with development of new generation to meet that need in a relatively timely way. So perhaps I'll leave it there for now, but I think general agreement with tactics as far as load forecast and deployment of additional tools.
Commissioner Plant, anywhere you'd like to go.
Yeah, I don't have too much to add. I'm in alignment with both of you on this. I think we're at a time where we've got uncertainty in pretty much every aspect of the electric system. I think on the customer sided stuff as it relates to EVs, as it relates to beneficial electrification, I think that those are things that we're going to be working through in other proceedings. And the impacts of those, are affected, yes, by, changes in incentive levels and what our assumptions are of adoption on the customer side, but also the capabilities of the utility to effectively manage how those resources impact the system. And I think that that's going to be something that's going to become, a sort of a baseline component of these projections. And then on the large load side, I mean it's just, I mean, just in the course of this proceeding, we've seen so many changes, both in the efficiency of, the capability of the various different chips that are used in these data centers, as well as, competing technological advances that increase the efficiencies of the overall systems. We've seen load projections that then are dramatically changed. And one of the things that I think was really impactful for me was when we did that analysis of going with the presumption of the load that's projected and what the cost would be on the rate base if those loads don't materialize. And that, really drove home to me the fact that by taking these high load projections and, assuming they will arrive, we're putting all of the risk on the ratepayer. And I think that we need to be more thoughtful than that, and we need to be more considerate of the ratepayers, particularly in this kind of a volatile environment. And so I think that if there's anything that we've learned from the 2021 proceeding, it's that planning for flexibility and for the ability to respond to changing policy environments, to respond to changing technological needs and electrical needs as they arise from single investments. I think these are going to be that's flexibility is going to be the absolute key in this proceeding going forward as it relates to the various different individual components of that. I'm sure we'll have good discussions around that, but I think that we need to see this as sort of a continuum and put in place the ability for the system to really respond to changes as they arise.
No, I appreciate it. And couldn't agree more on the need for flexibility and optionality, whether it's on the customer side or the supply side. So I guess what I'd like to propose is that advisors lead us through discussions at a high level, maybe not even summarizing all the party positions at this stage on large new loads to start with, then EV charging, then clean heat plan, beneficial electrification, maybe oil and gas, maybe a brief conversation on resource need, and then jump into the supply side flexibility. So I see maybe 4 or 5 areas of discussion, and we'll just flesh out where we agree, where we disagree, and take it from there. So would that work for you, Commissioner Gilman?
Yes.
All right, Commissioner Plant, is that a okay way to proceed?
Sounds good.
All right, Mr. Mendelson, if you're out there, can you, briefly tee up a discussion for us on large new loads, and we'll let each of us take it wherever we want to go, and we'll see what we agree on, what we disagree on, and take it from there.
Sure. Thank you. Good morning, commissioners. I'm Mike Mendelson of your advisory team. So the first prompt for your consideration is your perspective on large loads. As a quick background, in its direct case, public service presented a base and low case, the primary difference between the two being the inclusion of 1.7 gigawatts of new data centers that have begun the process of seeking service, but not yet under contract. In answer testimony, many parties raised concern that these data centers were phantom in nature and simply represented forum shopping by large tech companies amongst utilities across the country. They also raised concerns that the company would be building resources to serve these large loads without any real financial commitment or penalty for early termination. They argued such a scenario placed existing ratepayers at material risk of stranded investment and cost shift. In rebuttal, the company provided an updated base forecast with a reduced quantity of large loads of about 950 megawatts, which included 5 so-called strategic economic development customers, representing existing non-data center entities with considerable expansion plans. Public Service notes these 5 customers have lower probability of fruition per the company's load commitment rubric, but contends they serve important sectors of the Colorado economy, such as transportation, government, and advanced manufacturing. The company also presented via rebuttal a list of commercial principles that it would incorporate in contract negotiations going forward in order to protect existing customers from stranded investment. The commercial principles included such details as upfront fees, contract duration, and exit fees. In contrast, the company's low forecast included only large loads with a 90% or higher probability of fruition, meaning it includes customers with signed energy services agreements or interconnection agreement. The low forecast originally included 2 existing data centers that are projected to grow by 185 megawatts by 2031. A third data center reached the 90% probability threshold by the time rebuttal was submitted. Importantly, the low forecast excludes the strategic economic development customers proposed by the company. The commission also requested the company conduct a lower low forecast, which incorporates the company's historical growth rate. The updated base forecast is supported by the parties that comprise the framework, WRA, SWEEP, and Climax. CEC raises concerns regarding the array of uncertainties regarding the large loads, federal policy, and the economy generally. The framework requires the company to file a large load tariff by end of January 2026, which is generally supported amongst the parties. Public Service suggests that large load customers entering its system will take service on the Transmission General or TG tariff, and those customers should be allowed to remain on that tariff. Others suggest that customers signed prior to implementation of the tariff should still be subject to it. CEC suggests that relevant customers be given a fair notice that they will be subject to the large load tariff once implemented. Public Service explains that most of the strategic economic development customers take service at distribution level voltages, which somewhat further complicates this specific issue. Advisors note that we will eventually follow up with party positions and specific decision points on the appropriate probability assessment for forecast inclusion, the treatment of strategic economic development customers, the adoption and application of the commercial principles, and the application of the large load tariff and fair notice concept, among other details. However, in order to foster a general discussion on this issue, our prompt for your consideration is, does the Commission have any initial position on the treatment of large loads?
Thank you, Mr. Mendelson, for laying that out in that way. Greatly appreciated. I'll share my thoughts and see where you guys want to go. For me, on large new loads on this record, I'm not willing to approve new generation based on the company's subjective view of contract negotiation status. I think a more realistic starting point may be represented in Figure 5 of Mr. Iden's answer testimony at page 30, which shows that only a fraction of the fully executed contracts for new data center load in Dominion service territory, one of the national leaders in this area, actually came online. So I'm wondering, even for a load arising from signed contracts, if we need to explore some discount. For strategic economic development customers, existing customers who are expanding, it seems like the company is proposing to procure substantial generation resources for potential loads with perhaps limited evaluation and customer financial commitment. As one example, we have a company report which tends to contradict the size and timing of one of the largest of these strategic new loads. Another customer involves federal government-related demand, which, given the shifts in the federal workforce, again, struggling to approve new generation to serve that load while so much uncertainty exists. For me, these concerns are exacerbated by the fact that the company has not yet conducted a revised resource or rate impact modeling associated with the greatly increased supply costs presented in its rebuttal testimony. As such, we don't know at this time if the revenues from these large new customers will cover the rising costs of serving them prior to the January 26 advice letter tariff filing. For me, I would adopt the large customer loads that are included in the company's low load forecast, but recognize that it could be higher. Given this, I'm intrigued by CEC's proposal on fair notice, where we might direct the company to notify large load customers of the future January 2026 AL letter, advice letter or tariff filing that would address many of the issues on customer protections necessary to include these increased loads as prudent for purposes of the supplemental RFP in phase 2. In terms of providing confidence to large new loads that the generation will be there when needed, I agree with CC and WRA that we can do that on the supply side through multiple RFPs, the incremental resource need pool, and the SURF. I like the idea a lot of creating supply side optionality through hundreds of millions of dollars of investment without committing now to multi-billion-dollar resource acquisitions that may ultimately not be needed. I also have significant concerns with the company signing long-term contracts with large customers based on the existing tariff structure and prior to the resolution of the January 26 tariff filing, given that we don't understand whether the revenues from existing tariffs cover the greatly rising costs of serving these loads. If the company does choose to execute long-term contracts without PUC approval, it should be fully aware it does so without a presumption of prudence by this commission in this proceeding. I just say that for me, the company may be at risk of sharing the pain if these contracts later turn out to be subsidized by all other customers. Likewise, adopting the fair notice concept raised by CEC will help better ensure large new customers are aware of the future fully litigated customer protections that may apply going forward. Finally, I would not approve at this time large load commercial principles. My concern is that these principles would lock in place rate structures for 15 years that have revenues that may not adequately cover the costs of serving those loads. Given this reality, I'd like to take up these principles as part of the January 26 advice letter filing. Perhaps we could also set the criteria for bringing resources out of the incremental need pool as part of that process. So that's where I'm coming from. We can go back and go through each of these individually at the appropriate time, but I just wanted to lay out my thinking for you guys, see where you guys were coming from, and take it from there. So Commissioner Gilman, again, anywhere you'd like to go. If you're not prepared to talk now, we can come back later. Anywhere you'd like to go.
No, I'm prepared. I have some notes. I'll try to hit each of the same areas, but if I miss something, I can come back to it. Yeah, I really tend to agree with you with regard to it makes me very weary to include large load customers who have not even signed a contract. Now, those contracts in their current form likely do not necessarily include the types of ratepayer protections that I think are really what we're going to be aiming for. So the caveat is probably in their current form, they don't actually do the lion's share of what we would intend for them to do in terms of customer protection. And while I understand the company kind of put forth this argument that customers will not sign them without the certainty that the load will be built in order to serve them, I think it's fair that this commission could set the policy expectation that that is the first step, and that we're looking to deploy, especially these other iterative tools, to speed up our time to bring resources to bear in the situation where we have more certainty of load. But I kind of fundamentally didn't understand in that argument why it was then the case that ratepayers should bear all of the risk of the load showing up. that, that doesn't really make any sense, that the utility is essentially held harmless to the risk. The large load who says they're coming is held harmless to the risk, and the ratepayers would bear all of it. And at the end of the day, there are significant, economic and potentially technical risks associated with these very large loads. And we need to be sure that in moving forward, looking at what is fair for a forecast, and then what are our processes and tariffs to actually bring these loads online, that the existing ratepayers are not bearing the risk or being unduly harmed by what comes. So I think it's very reasonable at a minimum to go to the 90% level, which is a signed contract. I will note though, and perhaps one thing to talk about when we come back is the role of the commercial principals, especially in the interim. I think that's primarily an interim situation where we have general agreement that a large load tariff will be filed in January. That'll take most of 2026 to litigate. So we've got the entire time frame between now and when that's in effect that these customers could be coming online or hypothetically signing agreements or having these discussions with the company. And so how do we set the right expectation for what the parameters are in that time frame for ratepayer protections, other ratepayer protections? And so I personally thought the commercial principles were a good place to start with that. I don't know that they, achieve every single thing we want to achieve in all of the perfect ways, but, if your stance, and perhaps there's a way that they don't lock in a certain rate or a certain cost, right? Perhaps they float with the actual calculation, of marginal cost to serve. But I wouldn't go as far as you and say like they have no role right now. I think that's probably something we'll have to debate more, because I'm very weary of the idea of going another basically entire year and not having any of that, more emphatically communicated to loads coming online. So I think we'll have to work around the edges with what those look like and how perhaps you communicate them. Those are part of the contracts going forward. But perhaps there's some flexibility if those costs don't actually properly reflect system cost or something like that. Then let me see. So yeah, I think the interim is of a specific concern, especially as we hear all these speed to market concerns. I totally agree with you in terms of supporting CEC's kind of fair notice that we do expect that with the filing of this large load tariff, that would be the destination tariff for these loads. And so there should not be any signed contracts or otherwise communicated expectation of anything to the contrary. That would certainly not serve other customers well. And then, yeah, with regard to the strategic, I think for lumping that in as well, I have trouble with the general concept, I think, that only showed up in rebuttal of this non-statutory, newly, loosely defined thing. In essence, if we have customers, whether they are new or whether they are existing, and they would require significant build out to meet their loads, whether that's of generation, transmission, I think across the board, and whether they're connecting at distribution or transmission voltage, the expectation should be that they have signed an agreement that includes, a significant amount of the risk sharing in order for us to begin the processes to go secure those resources. So I just didn't maybe see the distinction that was trying to be drawn there. The loads still came off as honestly somewhat speculative. I mean, it's literally based on conversations. What was the description? We need more than conversations to build out billions of dollars of infrastructure. We need signed agreements at the proper level that include ratepayer protections, plain and simple. So I just didn't see the rigor or honestly the evidence that we're sure enough about these loads that we're prepared to really make these agreements. And I will say, I think it's important, like I said in the beginning, that we be strategic and supportive of load growth. That's not the intent in kind of limiting the rigor here. But I will note, when asked, okay, would you accept this risk then, this financial risk? The company's response is a firm no. And the company is the only one negotiating with, talking to, in some case, understanding the identity of these loads. This commission does not even know that. And much of the information has been provided confidentially, so it's very difficult to talk about publicly. So I understand there may be reasons for some of that, but with that, really the company is accepting a much higher portion of the verification and the risk of these, and that's a risk they're not willing to financially accept. So that's left with us in the middle trying to figure out, well, who actually accepts that risk then? And I think the case that was put forward is ratepayers, which does not make me comfortable with the information we have, or in most cases do not have, about the certainty of these loads. So I will just hope to position the comments in that way, that I certainly really hope to be supportive to achieve these other state policy goals, to achieve the economic development that many are hoping for. But it can't be at the entire risk to other ratepayers. That's not an acceptable solution here. And so that kind of put us in this position in the first place, to be perfectly honest.
Commissioner Plant, anywhere you'd like to go?
Yeah, thanks. I don't have too much more to add. As it relates to the large loads and the sort of the the chicken and egg problem of load doesn't want to commit until they know that there's supply, and the supply doesn't want to commit until they know that there's load. I think that what we're proposing here is, maybe an alternative path, which is we will approve a process for load once we get a commitment, or for supply once we get a commitment from load. And I think that that's as good of a middle ground as we can hope to achieve. But I also agree that commitment, in order to trigger that, needs to be a much higher level than what the company has brought forward. And I think that 90% is, sort of the level that we're talking about. But, really more specifically, assigned ESA seems to me to be the component. And that's where, these commercial principles really come into effect. And as to the comments by Commissioner Gilman, I think that we've got a year to a year and a half here of interim between when the large load tariff is approved and finalized and implemented, and where we are today. And those commercial principles really are contained within the ESA. And I think that there's things that I think we want to discuss and potentially add to that may be something that happens during the tariff debate, but we've got some criteria that I think are important there. The other piece that Commissioner Gilman really hit on is the strategic loads, which largely seem to fall in the distribution system, which then you're talking about a different kind of an agreement. And also, I think some different commitments on behalf of the loads that are located in that distribution system. They're also in a situation, quite frankly, where they can get to a very high level and back out much easier if they're already existing customers. And so they, in some ways, present an even higher level of risk. And I'm not sure exactly how we're going to address that issue. But these are while they're both large loads, they're different types of customers with different types of agreements and different levels of commitment already on the system. And so I think they're gonna need to be something that we look at in a different way through this proceeding. But I think I agree with your other comments, and the CEC proposal, I think, was a good and interesting one as well. So fair notice proposal. So agree with that as well.
Let me just ask you guys a couple questions to see where you're coming down in terms of the first phase resource solicitation. I'm sort of relying on the low load forecast, and anything over and above that would have to come out of the second RFP. Are we aligned on that, or are you thinking that you'd create a process and maybe adjust the resource acquisition before we go out to bid in early next year? Any thoughts on how you view the forecast, Commissioner Gilman?
Sorry, I'm trying to look at my notes. I believe the low forecast in terms, you're asking like specifically with regard to large customers, what if we would just
just large customers, yeah.
Yeah, I think for the low load forecast, it was just the two in essence, right? That are already essentially existing, although understandably like still ramping, so somewhat uncertain in terms of build out. Yeah, I would agree with that, especially because as I kind of articulated, I think the 90%, like having signed agreements is a minimum. And I don't actually.
Yeah, it's got to be the right agreement.
Yeah, 100%. Like it needs ratepayer protections, which is what I communicated, but I don't understand any other large loads to meet that criteria. So in essence, like I had talked about it from the other direction, but that is what's in the low load forecast. So yes, that would be the amount I would support at this point.
Commissioner Plant?
Yeah, I agree. I think that the low load forecast sort of takes us in the current commitments, and then going forward, we evaluate based on further level of commitment. So to me, it seems like it's pretty consistent with the approach that we are taking here.
All right, I think Mr. Mendelson, maybe that's as far as we can go on the large loads. I think we got maybe one or two of the decision points addressed, particularly for the first round RFP. I think how it gets documented, I think we need to, and sort of what guidance we want to give beyond that. I think we'll need to come back for a further discussion, but maybe we can jump to EVs now.
Sure. Yes, the second prompt for your consideration is with respect to electric vehicles. The company proposed EV adoption rates generally tied to Colorado's emission reduction policy. The updated base forecast proposed by the companies and supported by the framework parties and others includes a high EV adoption forecast of approximately 700,000 EVs in the public service territory, leading to 710 megawatts of incremental summer coincident loads and over 1 gigawatt of winter coincident loads by 2031. The company notes that approximately 125,000 EVs are currently located in its service territory, so the updated base forecast is assuming the addition of in excess of another 100,000 EVs per year on average. The company's low forecast incorporates a somewhat slower EV adoption forecast, culminating in about 100,000 or 1/7 fewer EVs assumed on the public service system by the end of this decade relative to the updated base forecast. While EV adoption rates were generally not challenged by the parties, the associated load curves were, particularly with respect to the peak mitigation capabilities of managed charging programs, including the company's existing demand response initiatives and future programs that are likely born out of the ongoing DSP proceeding. The company explained that about 10% of EV owners participate in one of two company DR initiatives, and the load forecast assumes that participation rate increases by 2.5% per year until it hits 70% in 2050. The company presented information at the technical conference that indicated the company's modeling assumes managed charging participants have a significant peak at 9 p.m. roughly, which causes new system peaks by 2028. To fix that impact, the company assumed customers are segmented into 4 additional tranches, which shifts the charging profile back by a set number of hours. Importantly, this part of the forecast was not tied to any specific program initiative or actual data. It was simply a mechanism to alleviate the coincident system peak in 2028 and beyond. I can explore party positions if desired, and we'll bring back specific decision points for your formal votes, but for the time being, I'd like to prompt the commissioners to offer their perspective on EV loads.
Again, thank you, Mr. Mendelson. And again, I'll just start out by saying I'm struggling to accept even the company's low forecast on EVs for multiple reasons. As Mr. Iden points out in his answer testimony, the company's regression modeling of EVs fails to account for the 125,000 EVs that are currently on the road, assuming that they are non-existent or negligible. By 2031, Piesco forecasts roughly 700,000 EVs, such that today's levels are 15% of that total. Removing 2024 EVs from the 2031 total to properly calculate the 24 to 31 expected load growth might reduce the proposed low scenario by perhaps 15% or 80 megawatts. Second, the company did not distinguish between all electric vehicles and plug-in electric vehicles with natural gas capability, despite roughly 30% of the EVs on the road today in Colorado being PHEV. Given they have an average battery size that is roughly a quarter of a full EV and more flexible charging needs, it seems reasonable to assume that 30% of the EV demand should be significantly reduced. Fixing this one obvious flaw in the company's forecast would seem to further reduce EV peak demand, maybe by as much as 100 or more megawatts. As Mr. Mendelson said, the company presented 2 EV adoption load curves, high and mid, with the mid having roughly 100,000 fewer EVs on the road by 2030. Even so, the mid forecasts that it's roughly the number of EVs currently in the state, a number that took roughly a decade to implement. Given that elimination of both federal and state tax benefits, I believe that both the mid and high projections may be too aggressive. Finally, fourth, Piesco assumes that 5% of EV, again, as Mr. Mendelson said, 5% of EV customers participated in managed charging in 2024, and that the share increases linearly to 70% by 2050. Mr. Iden recommends that Piesco increase the number of customers participating in managed charging to meet the 24-26 TEP goal, and that the company use an S-curve growth pattern to predict managed charging in future years. Applying an S-curve like what the company used in forecasting EV adoption, the percentage of EV customers enrolled in managed charging could be roughly 50% by 2031, or a very substantial increase from the 23% that the company now projects. Assuming managed charging customers would avoid charging during peak hours, EV load might be significantly lower by 2031 than what the company shows even in its low load forecast. Putting all this together, I don't believe there's sufficient evidence in this record to support additional new generation and other investment based on even the company's low EV peak demand forecast of 540 megawatts by 2031. For me, I think the evidence in this record, as just discussed, suggests that something more in the 150 to 200 megawatt range is appropriately supported. But again, for me to accept a reduction in the EV load forecast that delays new generation, I believe we need to be more aggressive about ensuring there is meaningful supply flexibility and optionality. So again, Commissioner Gill, as much or as little detail as you want, anywhere you'd like to go. And to the extent we need to bring that back later, totally fine.
Yeah, I think it would be helpful to bring back like the exact level. I'm happy to talk topically about honestly some of the concerns with with the forecasting and the modeling. And I think it'll also be important to kind of put all the pieces together. So while I think it's helpful to talk about these in the pieces, I think the final determination of what looks reasonable is kind of a summation question, probably in part. But I agree with a lot of your concerns. I really found the forecasting around EVs to be troublingly elementary. That they didn't distinguish, as you noted, between full EVs and plug-in hybrid EVs, a massive differentiation in battery size and charging time, and in the fungibility and flexibility of that load. A customer with an entirely redundant way to power their vehicle is far more likely to respond to pricing signals or be able to shift that load even on a short amount of notice. So they just strike me as entirely different use cases, entirely different amounts of energy, and potential peak impact. So that was a huge miss, but also in terms of kind of even how they modeled the management of the charging, I thought was very troubling to me. So, to me, I think part of the message here to me was we've got our work cut out for us in the TEP coming to really make sure that these programs make sense. The programs have to work together, right? So if we are providing a charger in one program, that charger must be compatible with the managed charging, which is a thing we'd really ideally like people to do, and moving to a significantly more sophisticated active managed charging, so that the company actually has these tools at its disposal, especially in the worst case, given a system emergency, but normal days to just manage the load. And so, I found also kind of a discrepancy between, honestly, some of the messaging and what we're being told in the TEP proceeding and here in terms of the benefit to the system, the peak demand impact. And so, to continue to pursue the TEP policies, which I very much support and want to see us go to continue, we have got to have much higher ambitions about the strategy and intelligence with which we bring these loads online. These loads do not have to hit at the system peak. And it is incumbent upon us when we're looking at that TEP programming. So I'd expect maybe by the end of our deliberations here, we have kind of a more precise list of to-dos for the TEP to ensure that as we're doing that litigation, we much more strategically plan those programs to be sure that this is a top line priority. We have got to be ensuring that we are bringing this load on in a way that really incentivizes it to be flexible, and to be flexible in an intelligent way, in an actively managed way, so that it actually provides the system benefit that kind of is the promise that comes with more electrification and more load growth. Part of that is ensuring that we really have the tools to manage that load. And I think that's been certainly, if we're at 5% managed charging, which I'll be honest, the record was quite confusing on the amount we actually are at right now, that's a huge miss in terms of the design and deployment of these programs. We should be at a significantly higher level now and have a much better ambition about how quickly that ramps up. Our first contact with those customers to assist them in getting the charger or whatever it may be is the golden opportunity to ensure that you're enrolling them in these programs. And so if we have such a low percentage, I'm really disappointed in the deployment of that. And so, I was tending more toward a mid forecast for EVs, but certainly appreciate your comments on a lot of the shortcomings. I share a lot of the concerns about the shortcomings. So anyway, just to summarize, I see this as a two-part problem. Pick the forecast here and then provide the right direction for the next TEP, because this is a solvable problem. And it's really disappointing to be in this spot where we're assuming this is something that's causing, kind of trouble for the system, when really I think we should be expecting it to be a benefit.
Can I just explore a little bit more with you on how you think about the forecast and the resource need? The base case was over 700 megawatts. The low was over 500 megawatts. I'm suggesting something closer to 200 megawatts. And you don't have to decide today. You don't have to share today. Just as Commissioner Plant and I go back and think through where we want to land, not just here, but everywhere. Do you have any guidance for us about how you would invest in new generation based on this record? 700 megawatts, 500 megawatts, 200 megawatts. I mean, that's really the decision in front of us. And again, I'm not trying to force you to decide today, we'll bring this back, whatever. But if you have any guidance on your thinking, that would help me as I struggle with my thinking.
Yeah, I think it's something it's something I can certainly look at over the next week or however long we're going to take before the next deliberation meeting. Certainly my goal would be to not diminish our ambitions about customer switching to EVs. There's clearly greenhouse gas benefits, operating cost benefits, all of the things. Like, we would like that to get to customers. So I don't want us to be standing in the way of deploying that. So I would hope like a diminishment in the forecast is not a significant lessening in the expectations of deployment of EVs, but rather in the intelligence with which they are hitting the system peak and our ability to avoid that from happening. So that's the differentiation with which I'll be kind of evaluating that. Is I really would like, as much as we can, to stay on track with state policy targets and ensure that the deployment is moving in that direction. But like, plain and simple, like, it is not our destiny that these charge on the peak all the time or even the majority of the time. And we have got to get, I actually think we have been trying to send that message for years, but this has been kind of a stark realization of the cost. And so we have to take a really hard line on that, I think, as we look at the TEP. So that's the differentiation I would say. I would very much like, and understand that like things have changed. We're at an impossible time to plan, certainly. But I would very much like to see us at least continue to try along the state policy path in terms of adoption, but get far more precise in how this is being modeled and in how these loads are being actively managed to ensure that they actually live up to the promise of benefiting the electric system rather than causing more costs.
Well, we got a multi-billion-dollar decision based on this in terms of new resources. Commissioner Plant, anywhere you'd like to go?
Yeah, I think the low forecast uses the mid EV model, and I think to me that seems like a pretty reasonable place. I mean, I'm willing to go back and look at it, but I mean, the big question around all of this is not. I mean, some of it is adoption, and I think mid is probably a pretty reasonable place to land on adoption. But the managed charging component of it is so huge as it relates to the resources that are required. And in the TEP, Piesco came forward with a 50% managed charging, and we're at 10, and I don't know if it's just because they are evaluating managed charging based on their own managed charging program, which is pretty lame, or if they're looking at, how the managed charging across all of the customers who have EVs is going to actually play out. I mean, in addition to the TEP, the other thing that we have coming up is the VPP proceeding. And right now you have a bunch of sort of aggregators in waiting. Every EV has got, an app. The chargers are manageable, but they don't have a program to participate in. So the question is, once there is a program and these participants can suddenly participate in that aggregation program, how much of this managed charging suddenly appears? And is it even going to be acknowledged as such because it's not a part of the company's, managed charging program. And we asked the company to come back. I asked the company to come back with an evaluation of how different rates, from they're assuming, that they're at 10% now and they're going to go up 2.5% per year until 2050, which seems just ridiculous to me. So, we asked them to evaluate what a higher rate of managed charging adoption would do, and they just didn't do it. So we don't really have that evaluation in front of us. But I think we have to assume that when there is a program that acknowledges managed charging and the value of managed charging, and you have those participants in that program, we are going to have a much higher level of managed charging. And I have not seen that reflected in their modeling at all.
Well, I'd just ask you the same question that I asked Commissioner Gilman in terms of megawatts of assumed load. Do you have it? And again, you don't have to decide today. We can come back and talk about it next week. Just any thoughts on where you land? It sounds like there's a consensus that we want to show the adoption rates pretty consistent with the mid-level and the TEP, but how you get from those adoption levels to the forecasted load and what that means for the new resource need. Any comments you'd like to share? And again, we don't have to resolve this today, but as Commissioner Cohen and I, try and get the three of us on the same page. Any guidance you can or are willing to share?
Yeah, I mean, I'm not prepared to say, what specific megawatt level, is right now, but I'll take a look at it over the next week. But where I feel pretty comfortable in adoption is the mid case, which was reflected in the low forecast. But I also, I want to look at how much of that is how much of the megawatt requirement in generation is due to just poor managed charging, which I think is going to change much quicker than in the forecast that the companies put forward.
And we may want to talk about some rate structure, some EV charging rate structure. So if you do charge on peak, you're responsible somehow to pay for the cost you're imposing on the system. Not in this case, but in a future filing. So that's another topic I'd like to bring back. I guess why don't we keep going to beneficial electrification, Mr. Mendelson?
Sure. The third prompt is with respect to beneficial electrification related loads, which include two primary elements, the adoption rate and the load associated with supplemental heating. Public Service generally assume BE adoption consistent with the Commission's order in the Clean Heat Proceeding, 23A0392EG, and other recent decisions. In total, the company is assuming adoption of 258,000 space conditioning heat pumps, with approximately 53% in hybrid systems and 47% in all-electric systems, and 565,000 water heating heat pumps in its system of approximately 1.5 million electric customers. Although the company assumed very efficient heat pumps adopted, it also projected the need for considerable supplemental electric resistance heating capacity, either designed directly into the primary home heating system or added as an additional heat source by the customer during peak winter conditions. This treatment led to heating related loads as high as 17 kilowatts per customer at a temperature of minus 22 degrees Fahrenheit. WRA challenged those heating related loads and noted that a leading front range heat pump installer testified in the CHP proceeding that it primarily designed systems without any electric resistance backup at all. And even for systems that did require electric resistance backup, the load of those systems ranged between 3 and 8 kilowatts. WRA suggested 3 kilowatts of supplemental and 10 kilowatts of overall related BE heating needs as an appropriate load for all customers given that set of facts. Public Service countered that the testimony was submitted by another witness in another proceeding and not relevant here, and that it applies a rigorous two-step process where the heat requirement for the building is determined first, and then the most efficient combination of available equipment is utilized to provide the required heat. Again, I'll present the commissioners with specific decision points either today or at the next opportunity for deliberation. But for the time being, I'd like to prompt the commissioners to generally discuss their position with regard to BE-related loads.
So I guess I'll start again and then turn it over to you guys. For me, I'm really concerned the company's actual implementation of BE will fall short of the aggressive adoption numbers used in the Clean Heat Plan. I also think it's important to remember that we didn't improve Clean Heat Plan spending levels past 2027, and the initial results of the company's implementation don't look promising. In terms of committing new generation to support beneficial electrification, I'm probably at maybe half of the company's low case peak demand growth forecast based on this record. In addition to the BE concerns over the BE adoption levels, I'd also note that the company included, as Mr. Mendelson suggested, some very concerning numbers with respect to the need for supplemental home heating, reaching up to 17 kW of load. WRA noted that according to a leading HP installer who testified in the Clean Heat proceeding, most home installations conducted on the Front Range required no supplemental heat. While this issue seems quite murky to me on this record, it's clear we need far better analysis in the future. I'll note that BE adoption and supplemental heating requirement assumptions are important because the company is projecting that its overall peak shifts from summer to winter in the 2030s, and BE impacts increase by a factor of 5. For now, I think the company's BE adoption presentation supports acquiring new generation levels, like I say, that are maybe roughly half of the company's low load forecast, but really curious to hear where you guys are coming from. And again, you don't need to pick a number today, but if you would be willing to share whatever thoughts you're willing to share, I think that would help frame up our ongoing conversation. So Commissioner Gilman, anywhere you'd like to take?
So yeah, really, I think in total, very similar comments to in the EV side of things, where, I think the policy goals are still worth supporting and like moving in that direction with that ambition. But the way in which they've manifested into the forecast leaves enormous room for doubt if we're looking at the right numbers. So first, as you point out, implementation seems to have been going slow, but I've got to be honest, disappointingly, the company did not sponsor a witness here in forecasting who could tell us what was going on in terms of deployment of clean heat and BE. So it's a little hard to say, but it certainly seems, at least in terms of obviously 24 spending and when those programs really took flight, that we may be behind on some of that implementation that the company's in charge of. Second, and a major concern for me, is the company has put forth entirely different assumptions in their forecasting for gas system related proceedings. In their base case, in the gas system, they essentially assume the Clean Heat Plan does not exist. And then here, they assume it's been entirely successful. So clearly, these are difficult to take at the same time, both called the base situation. Well, the base situation of what we expect to transpire has got to be the same thing. It has to be the same vision. And understandably, it is not known. That's why it's a forecast. And that's why we've been doing low and high sides of it to kind of try to feel out the edges and understand what more successful or less successful implementation of certain programming or policies might look like. But it is kind of breaking my brain to try to understand the knots we're twisting ourselves into to say there's an entirely different future on the electric system or the gas system. And that to say, I mean, one of the potential benefits of beneficial electrification should come with some decreased spending on the gas system. And so if what we're being presented with is a forecast in which we essentially continue to invest full scale in both, that looks very expensive to customers, and just for essentially services to provide the redundant service of heat to those customers. And so I think this is something we really need to address here, as well as in the relevant gas proceedings, that these forecasts have to make sense together. They have to be consistent. And anything short of that looks like really overinvesting potentially in both systems to support a divergent future at the same exact time, which just doesn't make sense for customers. The other thing, as you pointed out, kind of similar to the vehicles, right? We have the adoption curve and how quickly and well that's going, but then we also have the actual peak impact and use of those customers. And so those are two different parts of the equation. I would certainly hope and prefer that we're moving in the policy direction in terms of adoption, but understand implementation may be slow thus far, and there are potential additional challenges given lack of federal support now for many of those same, technologies. But in terms of the impact of the system, there are significant doubts both in this record as well as in others if what we're looking at in terms of I think you said 17 kilowatt peak impact per home is really realistic. And I've seen this honestly on the gas side of things as well, where what it appears is that the company is taking essentially the worst case possibility and then saying that's what happens to everyone. Which
at the same time.
Yeah, everyone at the exact same time. None of the homes are new, that can kind of vary when they heat to provide some diversity. And that is nonsensical. We have to have more strategy, more intelligence in how we're deploying these resources, both with trying to, at the same time, move to more demand response, demand flexibility, through VPPs or whatever. But as you're deploying the electrification programs, we should be ensuring that these customers are enrolled in multiple programs to enable them to help benefit the system. But also just in terms of the even likelihood that every system that's installed looks like that one, looks like the worst case. And understandably, we got to pick a number, we got to pick something in the forecast, but why that needs to be the most ultra conservative kind of worst case situation is not explained, and perhaps is not explainable, right? We need to, at least in terms of the peak impact per customer, look at the variety of situations, including, as you pointed out, as we've heard, a majority of which may include no backup at all. So what does that do to your average, right? So, and this is perhaps a little easier here than in the DSP, right? Because here this is kind of a system average situation. DSP, it perhaps needs to get more precise, because then you'll be looking at kind of more localized impacts. But anyway, there's a lot of ground to make up here in terms of our treatment of new and existing system assumptions, in terms of really varying the idea of what this might look like as it's deployed, to make sure we're coming out with kind of an average system impact that looks to make sense. Per home, I don't think we're here now. So certainly this would argue toward lessening this peak system impact, but largely on the grounds that the technical basis of what each home looks like feels like a very significantly large and potentially outside case to just be multiplying and applying by everyone, which is a big problem.
Well, again, and not trying to pin you down today, because I realize it's premature, but over maybe the next week, we'll bring this back on the 13th. So if you'd be willing to think hard about what number you'd like to put into the forecast, and then we have a whole separate discussion about what we'd like to see going forward. But if you could just think hard about that over the coming week. I sort of landed at half. Really curious. It sounds like you're open to reducing it, but if you could think more about that over the coming week, that'd be great. Commissioner Plant, anywhere you'd like to go?
Yeah, I don't have too much more to add to Commissioner Gilman's comments as well, and appreciate her insights and comparisons with the gas proposal. I would note that this is interestingly the BE component of this plan is one that doesn't really change across the different modeling scenarios, whether it's base, updated base, low. It's pretty consistent. And I have similar to your comments, Mr. Chairman, I have a hard time imagining that there's not some sort of an impact in the adoption levels of beneficial electrification. But a lot of that has to do with, as you're talking about what happens in the future, which, we don't know. I mean, there are projections that increased exports of natural gas are going to drive up natural gas prices. That could lead to more beneficial electrification. Of course, the reduction in incentives on the federal side really hits beneficial electrification pretty hard because it's a high dollar investment. And so, um, it- but then we're also looking at different programs going into place, from financing programs and things of that nature that could help it. So it's really, that number is, I think it would be hard to say it's not going to be impacted in any way, but the degree to which it's impacted, I think is a difficult one to come down on. I really share a lot of WRA's concerns that they raised in their testimony around the assumptions of backup resistance heat and how that contrasts with the experience of actual people installing these things in the field. I think we have a huge gap there. And I think we need to figure out, what the appropriate pathway is on the modeling side. Because I just think that the way the company is approaching this is just not aligned with sort of real world experience. And again, it's similar to EV. It's sort of, we've got the number. What number do we, of installs, and then how are they getting modeled? And the two of those things together, I think, are going to have some sort of an impact on what your overall requirement's going to be. But share those concerns as well.
Well, I
I
just
think-
again, oh, go ahead, Commissioner.
Oh,
Miller.
sorry. I was just going to chime in to Commissioner Plan's last point. I totally agree. I mean, one of the things that's the most difficult in a lot of these records is not a ton of real analytical data on how these are performing in the real world, how many are going in with backup, without backup, gas backup, electric backup, how are they actually performing at different temperatures? Is there really no contribution, from the heat pump itself at those temperatures? And so what efficiencies should be expected on the electric side or when with gas chime in? So I think we really need to have our eyes open for opportunities to gain some of that data or potentially collect some of that data or look for where it might, I used to have hopes maybe one of the federal labs would help us or something, try to figure out what's out there, because at the end of the day, like the company has AMI deployed, which customers paid for. This should be trackable, right? This should be knowable. And so I think we need to look again, like across the proceedings in which the deployment actually happens and those decisions are actually made, to be looking at reporting requirements to ensure that we're getting as relevant, like locational, climactic information as possible to understand how these things are actually going. Because in the absence of real data, we have like these wildly different assumptions and everyone's saying, no, we're right, not them. And like, it just strikes me with AMI fully deployed, like, and these things being deployed, right? Like we have heat pump programs, the company knows who is getting them. They're giving them the rebate. We could have a much better effort to actually collect and track information on actual usage, peak usage, how that compares to the house before. So just wanted to throw that out there. Like that is within our control, largely in other proceedings, but we perhaps need to take a much more serious look at like how important it is for resource planning and for the billions of dollars we're looking at across proceedings as far as like what is the actual impact. I think we have tools at our disposal to get that in the coming years.
And I'm prepared to put some guidance and recommendations in the order because I strongly agree with both of you. And I just ask you, Commissioner Plant, over the next week, as you struggle with the adoption rates and what it means to the load forecast, how coincident the peak's going to be. If you have any guidance on what you see for the load forecast and what it means for the resource need and new generation we're going to approve in this proceeding, that'd be great. Oil and gas, I think the last one on this component, Mr. Mendelson.
Yes, the last prompt I'll offer before any specific votes, if desired today, is related to the company's oil and gas electrification assumptions. Notably, this issue got very little attention by parties via answer testimony or the hearing. The updated base forecast includes oil and gas electrification of 364 megawatts by 2031. The low forecast includes only 151 by 2031, a difference of over 200 megawatts. At the hearing, Mr. Goodenough explained that the company does not apply the commitment probability rubric to these loads. Instead, they are simply conveyed by the account managers, and given the emission reduction requirements of the state, Public Service takes these load projections at face value. He also noted that load projection represents roughly 10 oil and gas drilling entities, and that electrification load did not materialize in 2024 as expected. Given that limited level of information, does the Commission have any initial thoughts on the inclusion of the oil and gas electrification values from either the updated base or low forecasts as presented by Public Service?
As Mr. Mendelson said, I think the record is thin on the oil and gas electrification, but I'd be prepared to go with the company's low forecast of 151 megawatts in lieu of anything else. But again, if you're not ready to vote or agree today, we'll bring it back next week. But Commissioner Gilman, any thoughts on oil and gas?
Yeah, I mean, just like at a very high level, why is oil and gas different than another large load coming on the system? So like to the general principle I expressed before, that to the extent this load would like us to build out infrastructure for them, a signed agreement perhaps is the way to get that or to get more certainty. So I'm just struggling with like, why would this particular industry have different standards as far as like a conversation with someone at the company? I've already stated, I think for other large load customers, that's not a sufficient certainty with which to invest millions or billions of dollars. And so, yeah, just like for the two of you, should the expectations be relatively similar in terms of, how large, but that, we hear generally across other systems, the company, the actual action that causes the company to build and supply infrastructure to customers generally is an application, a signed agreement, something more. Here we're hearing a conversation. And so I would say let's think of treating it similar to the other large loads. If you sign an agreement that includes some risk sharing, we're ready. Let's do it. Let's include it in forecast, but I'm just not sure why it's different.
So would you put it at 0?
I'll be honest, I don't know if we have the information on like their level of progress because they said they don't use at all the same process, right? So like, I have no idea, did not get any insight from the company. I think that's probably direction we could give the company into developing their forecast, is that you can include them to the extent to which they have signed agreements to take the service, with appropriate consumer protections, and they can tell us what that load is in that forecast.
Commissioner Plant, thoughts?
Yeah, I really like that approach, Commissioner Gilman. I think it makes a lot of sense. I hadn't thought about it that way, but I think you make a really good point. There's a couple hundred megawatts difference between, you know, what the company said they expect to come online and what they've already got commitments to come online, or and there was really, as far as I could tell, no evidence, no argument, no nothing really supporting it. It's just sort of here's a number. So I like Commissioner Gilman's approach of, you know, just using a standard commitment level and for the basis of any kind of approval. So
I like it too, and it's shifted my thinking. I'll just share some final thoughts on all this. For me, putting it all together, although this is all before I got to hear from you guys, I'd suggest reducing the low load forecast by, maybe 350, 400 megawatts of peak demand to create an adjusted low case peak demand forecast, mainly by reducing the EV and CHP stuff the forecast as I talked about. And with that, for me, it's figure JTL-SD-5 and Mr. Landrum's supplemental direct testimony, sort of looking at the resource need under a lower load forecast. And that showed, just under 4,700 megawatts of new supply, including 350 megawatts of storage, just under 3,000 megawatts of wind, 1,000 megawatts of solar, and 350 megawatts of gas. In contrast, the low load forecast, it's on page 73 of the technical appendix, shows just under 7,000 megawatts of new resources, including 400 megawatts of storage, 3,900 megawatts of wind, 1,500 megawatts of solar, and 1,000 megawatts of gas CTs. As such, the adjusted low case forecast might result in 2,000 megawatts less of total resource need and maybe as much as $4 billion less in investment as compared to the company's low scenario. So still massive investments, but maybe not as much as in the low case. So that's where I'm landing. I don't know if I just request you guys think about it and look at it over the coming week and see what you think, because ultimately we're picking a load forecast and a resource need. And if you want to leave some of it to a future process, we could do that. But I think we're going to do RFPs in early March or early next year. So we've been asked to pick a load forecast and a resource need. So I'm prepared to move on, but any comments on any of that, Commissioner Gilman?
Yeah, no comment on your numbers right now. I will look. But one thing, especially with regard to if we're seriously considering, which sounds like we are, the supplemental RFP idea with like a really abbreviated process for that going out, that's not going to be like a total recreation of phase one with an evidentiary hearing. I think what would be helpful in the forecasting, to the extent like that one will have its own different forecast, but with like limited process. I think it would be helpful that in addition to coming up with the numbers, this first go around for the base RFP, that we articulate the actual like methodology, and I think that's what I was trying to do is, large loads can be included if they've met X criteria, because we're going to have to grapple with how the supplemental RFP load forecast comes together with little to no process. And so I think if we can, in developing this base RFP forecast, be articulating the methodology in addition to potentially the actual megawatt values, that would provide, I think, far better guidance for the supplemental RFP, so that we don't get something nobody's expecting or doesn't kind of match the base RFP methodology and run into more problems that we were bargaining for with that process. So that would just be my ask, is like, let's try to articulate potentially a methodology in how we got where we got. And understandably, like, some of the forecasts are not incredibly well supported, so the methodology is a little more difficult, but that would be like part of my goal here.
Totally agree. And just as you think about it over the coming week, I think for me, I'm going to want to try and decide less of that in this case, given the commercial principles came on rebuttal, and try and defer more of that towards the January 2026 tariff filing to sort of put structure on it, especially since we don't have any economic analysis, based on the rebuttal testimony costs of what rate impacts are, what the Encompass modeling is. So that's my thing, and just we can talk about that more next week. Anything you want to, anywhere you'd like to go, Commissioner Plant?
No, I don't think I have anything too much to add. I think that I would just underscore, having some clear and predictable guidelines that both both the demand side and the company can understand, and all the parties understand, or sort of agreed to principles, for adding to our base case, I think is really an essential component of this to get everybody on board.
All right. I think what I'd like to do is maybe take a 5 or 10 minute break and then come back with Mr. Eden on the supply side. Mr. Mendelson, I think we got a lot to chew on, and I don't know how we present this efficiently next week, quite. But you okay if we turn to the supply side?
Sure, of course.
All right, let's take a 10 minute break till 11:05, and we'll come back at 11:05 and go to the supply side. Thanks. All right, Mr. Mendelson, you want to go to the supply side flexibility?
I'm sorry, I believe you mean Mr. Eden.
Oh, sorry, Mr. Eden. Tony Michaels, Mike's Michael. Mr. Eden, thank you.
Yeah, sorry, stuck with me for this one. And just kind of like the you all were discussing at the end of Mr. Mendelson's presentation, the other piece of this, the supply side flexibility, and as I indicated, advisors can see the phase two framework and the SERP as being both components of that. So if it's okay, I'll just put both of those concepts out there at a high level and then turn it back over to you all for a broad discussion.
That'd be great.
Public Service urges the Commission to approve the Phase 2 framework as a way to increase flexibility. This Phase 2 framework includes one, a JTS base RFP in 2026 and a JTS supplemental RFP in 2027. Two, an incremental need pool of paid backup projects. And three, a process and set of next steps to advance transmission deliverability projects for the JTS base RFP and proactive projects to facilitate the JTS supplemental RFP. For purposes of your discussion today, advisors recommend focusing on the INP and the supplemental RFP components of the Phase 2 framework. Staff, the Colorado Energy Office, or CEO, and the Colorado Independent Energy Association, or CIEA, join Public Service in support of the Phase 2 framework. Several other parties, however, recommend modifying various aspects of the Phase 2 framework. The INP is perhaps the most contested component. As currently structured, the INP would consist of a pool of backup projects that elect to receive option payments in exchange for agreeing to remain exclusively available to public service for up to 2 years. If a project failure or an incremental large load arises, all participating projects in the INP will be allowed a limited price refresh. The company would then notify the Commission of the INP activation and provide a brief alternatives analysis and an updated loads and resource table. Interveners would have a brief period in which to respond to the company's proposal, either 14 or 45 days, depending on the proposed size of the INP acquisition. Similar to the Phase 2 framework, the proposed Strategic Resilience Reserve Fund, or SRF, is also designed to increase speed and flexibility of developing and interconnecting certain resources. As proposed, the SRF is a $500 million fund designed to allow the company to acquire long lead time equipment like CTs, transformers, and breakers. Under the company's proposal, SRF expenditures would be entitled to a presumption of prudence, and CTs acquired with SRF funds could be used by the company in its JTS bids. In response to intervener concerns, Public Service states it is open to establishing acquisition targets instead of a flat budget. The company estimates that a $500 million budget could acquire approximately 3 turbines, 10 to 15 transformers, and 40 to 50 breakers as an example. Several interveners oppose the company's SRF proposal, especially as it relates to using SRF to acquire CTs. CIEA and CEI recommend approving a significantly modified SRF in which the company could only acquire breakers and transformers. Under both CIEA and CEI's proposals, breakers and transformers acquired through the SRF would be made available to both IPP and Public Service on an equitable basis. And I'll pause here for your discussion unless you have any questions.
Thanks again, Mr. Eden, for the incisive presentation. I'll throw out my thoughts and let you guys go wherever you'd like. Given my view of the still large but lower approved load forecast and resource need, I'm strongly supportive of many of the key elements of the Phase 2 framework. More specifically, I think a single Phase 1 decision that sets the modeling assumptions and other requirements for 2 separate RFPs is largely sensible, but that we may need to make some tweaks prior to the supplemental RFP, which we can discuss either now or in coming deliberations. Overall, I like the idea of a base RFP that would come out in 2026 for resources through 2031. I also think the general idea of an incremental resource need pool that uses paid backup bids to respond to increases in demand or project failures is a critical component of adopting an initial load forecast that is materially lower than the company's base and maybe low load forecast. At the same time, however, I'd like to add some additional notice and comment process to ensure that there's adequate PUC review before resources are taken out of the incremental resource need pool, particularly in response to an altered demand forecast. I'm not prepared to set a standard now in this case that describes what contractual or other features of a large new load would allow the company to commence acquisition of new resources, but would allow for backup bids to move forward using the INP price refresh process proposed in the Phase 2 framework. To ensure the bid process, refresh process is fair, I'd like to suggest we adopt some of the guardrails in line with the concern UCA raised in its SOP. As such, I direct the parties to develop safeguards that make sure the company is not able to see the results of the price refresh before submitting its own bid. Maybe that means the IE stays involved somehow. Regardless, the company should set forth its proposed safeguards in the 120-day report. I also support the idea of a supplemental RFP that would come out mid-2027 for resources from 2027 through 2033. Although again, I'd like to make sure there is appropriate notice and comment procedural protections in place that allow for sufficient commission review of the company's, particularly the company's demand forecast. Finally, I'm generally supportive of the SURF, especially regarding breakers and transformers. I also think it makes sense to get in line to procure 2 to 3 combustion turbines, but I'm concerned about giving the company an unfair advantage in the JTS competitive process. So I'd allow the company to acquire the turbines, but potentially exclude them from the JTS solicitations. As such, these turbines would be reserved for situations where the thermal projects in the approved portfolio fail, we run out of backup bids in the INP, or we somehow need to develop more firm capacity resources on an accelerated basis to meet growing load. For me, spending several $100 million now is a relatively small price to pay to help ensure we have sufficient capacity moving forward, given an uncertain future, as the ultimate responsibility for RA lies with the company. In addition to requiring the combustion turbines, I would request that the company complete development on at least 3 combustion turbine sites, including air quality and all other permits, so that they're available if needed, but not to start construction without PUC approval. I'm also supportive of acquiring 10 to 15 transformers that could be used for both IPP and company projects, and 40 to 50 breakers, which also could be used for both IPP and company projects. My concerns parallel those raised in the recent letter from the governor, such that I'd like to also explore using SURF or other funds to pre-order equipment so that renewable energy equipment, so the company can maybe start construction on certain wind and solar projects in a way that safe harbors the projects for future tax eligibility. The company also suggested a possibility, possibly including renewables in the SURF when it initially proposed the concept. In sum, I'm proposing to reduce the load forecast in a way that would lower the initial stage resource acquisition by roughly 2,000 megawatts and $4 billion versus the company's low case load forecast. To pursue this no regrets approach in a way that is responsible and creates future optionality on the supply side, however, I'm suggesting that we support the second RFP, the incremental need pool, and roughly $500 million in SURF money to ensure we have the flexibility to respond if the company's demand forecast turns out to be accurate. So I throw that out there, and so you guys can think about it and have it in front of you as you grapple with the same issues. And I would really like to hear whatever you're prepared to share now. And I'll find a way, either through a transcript of this deliberation or through providing a script to advisors, so you can get this in writing. So Commissioner Gilman, anywhere you'd like to go, your thoughts, comments on my thoughts, anywhere.
Okay. First with the supplemental RFP, I think it's a reasonable way to move forward, especially given the uncertainty. I think we'll have to put some expectations around what the process looks like, especially with regard to the delivery of the forecast. For that, I mean, forecast is one of the most hotly contested issues here. We can't very well have another RFP with a forecast no one's really seen or had an opportunity to comment on. So we're gonna have to put some ideas around essentially like an abbreviated process to ensure that interveners can comment on that forecast. And I would say probably front loaded in that process, you know, within perhaps even a week's time of when that forecast is delivered, we could consider holding a technical conference as well to really allow the commission, potentially parties, to really understand what is in the forecast. If we want an abbreviated process, we have to really provide the opportunities to move things along much faster. And I think a technical conference is potentially a way to do that, where we actually have an opportunity for that live interaction with the company to understand what is being assumed, what's in the forecast, and in pretty short order, you know, really understand both our impressions of it as well as interveners' impressions of it. So I would just throw that out. Also, with regard to the supplemental RFP, I agree with the Conservation Coalition that the 2021 ERP settlement agreement does not guarantee the company a 50% ownership share into the entirety of the supplemental RFP's timeframe. So I don't think that's reasonable to set. There would be nothing to really substantiate that. So I believe in the supplemental RFP, there would not be a specific ownership target established by any mechanism in that. Then moving on to the incremental need pool, I also agree with you that I think this is a reasonable part of the process, especially to enable us to act fast in adopting a lower initial forecast. Although I would say it would be my expectation that the criteria or commitment level with which to activate the incremental need pool is similar to that which would get you in the forecast in the first place in the RFP. So with regard to large loads, the strategic loads, you know, whatever it is, I think that same level of rigor is necessary because this means we are actually starting to develop resources really specifically to serve this need. So we really need to ensure that that load is coming through some of the safeguards and criteria that I discussed before with regard to large and strategic and oil and gas loads in the forecast in the first place. And I agree with a lot of your other thoughts on incremental need pool, especially ensuring kind of an arm's length for the company to make sure that they're not getting information that they shouldn't necessarily have access to kind of midstream. And then with regard to the Strategic Resilience Reserve Fund, or the SURF, I think the concept can work. I was thinking of it significantly more as only for transformers and breakers. And in doing so, that should be available to both IPP bidders and the company in equal parts, however that works and however we can verify that. This has, you know, the SURF concept in total has some advantage to moving speed, especially for areas where we might have supply chain issues, to be able to get projects online at the speed that we otherwise could. But it also has like some very serious anti-competitive problems in terms of the company being the one who would be able to acquire the rights to this equipment and them being a bidder in a process where we're trying to really ensure that we have a fair comparison. So, you know, and just simply put, we all know this, but like other bidders don't have the privilege of having someone else's money to help them secure spots in the supply chain. So the anti-competitive nature with the company and the bidding concerns me quite a bit, as well as we're only picking one resource, right? Like the proposal with gas CTs, which also concerns me quite a bit in terms of giving one advantage to, okay, we've solved supply chain issues or helped solve supply chain issues in one area and not with other types of technologies, which is potentially not ideal. So, I would certainly err more toward supporting it in a limited capacity. They had about 200 million in there for breakers and transformers, and ensuring that those are available to all bidders to ensure that we can meet the speed needed, and probably potentially even prioritize to ensure we can hit any requirements in terms of speed to bring on any tax favored resources in the time in which that would matter. So, I can consider, I'll tell you, I was not inclined to support it for gas CTs, and despite good intentions, I think the downsides are significant in terms of competitive concerns, and I'm not sure how we can cross that. So leave it there.
So here, let me just give Commissioner Gilman something to think about in the next week. So for me, the low load case is showing over 1,000 megawatts of CTs. I'm proposing something that would have a lower load forecast that might involve 350 megawatts of CTs. So in return for not approving the construction of those CTs now, I'm suggesting that we explore reserving equipment that wouldn't be allowed to be bid into the JTS or the any of the bids. It's just a reserve in case we need it. So that's the trade-off I'm looking at. Delaying approval of of just signing off on it, letting construction happen now, in return for just reserving spots, which I think is, more than an order of magnitude less of a commitment. So just as you think about it over the coming week, that's my thinking, and you may not be convinced by it, but at least I wanted to explain it.
So if you reserve spots, but you're not going to allow them to bid it in to either RFP, at some point they'll be expected to buy the thing or not.
Yeah, I think.
But they haven't been allowed to bid it into an RFP. So I just don't understand all the kinks in this.
Yeah, I mean, I view, and I may be wrong, but my sense is there's a secondary market. So if you need it, you use it. If not, you just move it on. And I think they're doing it at the holding company level. So it's over 8 or 10 states where they can use it. And I may not convince you. You may change my mind, but I just wanted you to understand where I was coming from, and maybe we do let them bid it in. But I share your competitive concerns.
Yeah, and I will say, with regard to the competitive concerns, we also heard in the hearing and are aware, the company has pre-ordered this equipment, right? They're already doing this, so they're essentially asking for basically ratepayer backed, risk-free way for them to get their assets, when that is something they're already doing. So it's not entirely clear from the record that the company would not do that in their quest to provide reliable electricity anyway, even without this mechanism that has the significant competitive issues.
I'm going to struggle to approve a load forecast that's moves it down from 1,000 megawatts to 350 megawatts without something, I think, more. So that's the struggle for me. And we may need to hear what your view of the load forecast is. But the low had over 1,000 megawatts of combustion turbines, and I'm struggling with that. And part of my way to address that reliability, resource adequacy concern is through this SURF. So and again, you may not agree. I may change my mind after thinking about your comments, but that's a thought. Commissioner Plant, anywhere you'd like to go?
Yeah, as it relates to the supplemental RFPs and the IMP, I'm in agreement. I think the one component, I really, by the way, like the idea of the technical conference you brought up, Commissioner Gilman. I think that's a really good one. If we're going to have some sort of an abbreviated and accelerated process, I think that would really provide a great deal of insight for all of the parties as well as us. So I like that. I think that, when it comes to the surf, I'm less enamored with this, with the whole process. I think as CEO and trial staff both pointed out, they've already secured deposits for CTs separate from the surf. And it seems like it's kind of an operation of the business that you would do that, and a risk that the investors take in the company as opposed to putting that on the customers. I would also point out that one of the things that I found interesting was that while the company is asking the SURF to have the customers put up the money for these deposits, they're proposing to share any revenues from the sale of any stuff that they didn't end up needing, which I think is also a little bit strange. So it seems to me like the SURF, the purpose of the SURF is one that has been traditionally and is currently being absorbed by the company itself, and I have not seen good evidence to push that risk onto the consumers. I'll take your point, Mr. Chairman, about we're doing this as a part of a whole and a lower load forecast. But that's where I also see primarily the IMP and the supplemental RFPs and a clear process for moving forward at a stated level of participation from a large load customer, and an accelerated process. All those sorts of things I think are really to address that, and I don't know how much the SURF contributes to that objective. But I am willing to take another look at that over the next week or so. Also, I think your point about particularly how it may relate to speed to market for some of the renewable resources as it relates to some of the uncertainties in the federal incentives, I think is another thing to consider as well. I'm not sure to what extent the SURF is going to contribute to that, but we'll look at it within that light as well.
Yeah, I appreciate it. And the concern is that when you get to the supplemental RFP or the incremental resource need pool, you just got to make sure the projects are advanced enough that they can come online quickly. And maybe there's ways of doing that without spending $100 million to reserve a spot in a combustion turbine queue. But as you think about what the resource need is and what the load forecast is, I just see it as a package. So curious to see where you guys land in the next week. So that was a discussion I wanted to have. It seems like there's a lot of alignment among the three of us. I want to go back and think about what I heard today. And I think next Wednesday, I'd like to try and resolve as much of the issues we talked about today as possible, load forecast and the supply flexibility. I think I'd also like to talk about whether we want to do a conforming bid policy and as much guidance as we can on that. So it does So I guess Commissioner Gomez, so any comments to today's process work for you? Was this a good way of doing it? And are you all right with that proposal for next week? Or since we don't get to talk outside this concept, any advice, guidance, comments from me as or all of us and advisors and council as we try and frame this up over the coming weeks?
Yeah, maybe just a thought first on our SURF IMP discussion.
Oh, okay.
If the concern is having really like speed to implementation, right, with certain resources, I just wonder if like we also have the incremental need pool full concept, right, of these resources that we've already seen, understand the price of, etc., far more detailed than whatever could be in the SURF, really, which is just a piece of equipment, conceivably, not even tied to a location or anything like that. Maybe we think of these more similarly, like if the incremental need pool is being paid to essentially stay available, maybe the question is how available, how soon, how quick can they act? Like, are they making progress, or are they expected to make progress in permitting or different land issues or whatever? So I don't know. I just getting the gears turning in my head of like, perhaps some of your concerns with SURF can be better addressed by more definition on incremental need pool, and like, that like perhaps we have to think about like, is there expected progress to be being made for those resources, so that it's not just the resources available at that location, but there is also a speed decrease. Just to throw that out there, I'm just like trying to think in real time about how to.
Yeah, that's the core concern. It's right. Like say EV demand does go to 700 megawatts way quicker than what we're expecting, or a large load comes on way quicker than what we're expecting. You just really want the flexibility to meet it quick. And I would support developing the CT sites, just as backup in case we need it. But you're right. There may be other ways of doing it that I'll think about through the incremental resource need pool.
It just might not be a totally separate concept, like, because even in the SURFs, it was like, well, we'll get spots for these CTs, but like, I have no idea the actual eventual cost of them or where they'll go and what transmission needs that could bring on the system. And so maybe like the incremental need pool has more rigor and like understanding the actual cost and placement of the resources. And so maybe that's the right place to focus on speed to market and then trying to accelerate the timeline. So I don't know, just throw that out there. It seems to me we have far more insight into those projects.
Yeah, you may be right. I'm really reacting to what Mr. Landrum told us at hearing, that the company feels like it's behind now. And, like we talked about, I struggle with the load forecasts, but there's just so much massive uncertainty. And I want to err on the low side as we approve construction, but create as much optionality as we can if we are wrong about that. And just have humility that we could be way wrong. So the SURF may not be the best way of doing it, and I'm happy to brainstorm it, but I'm just really nervous that we're already behind, and I don't want to not have backups if we get it wrong.
I'm good with all that, and I agree. Look, according to the loads and resources table, we may well already be behind. But hearing that sort of urgency, like in the hearing from the company and in their testimony, does stand in contrast to the delays we've seen in CPCNs coming from the company to actually develop the resources that were already approved. So I just want to point out, like, it does us no good. It does anyone no good to see delay on one side of the equation, and then this like expression of urgency. I'm not seeing that urgency necessarily being reflected in their actions, so I will just say that as a contract.
And they are losing 500 megawatts wholesale load, so.
Oh, but you asked about next week.
Yeah.
Okay,
that's
I know
all
you
right.
said-
Anywhere you want to go.
I took it literally. I know you said conforming bid policy. What else did you say?
And just follow up on this.
Okay.
So
Maybe
really
more
the
precision with numbers on this and conforming bid
yeah,
policy.
yeah, and take votes and resolve it.
Okay.
And I'll have to work with we'll all have to work with advisors and council to do it efficiently, so we're not saying the same thing
Yeah.
all over.
I think that works. Thanks.
All right, and you were okay with how today went? The discussion
Yeah.
today, would you?
Yeah. No, I think
Okay.
this is helpful to like have the high level discussion, but at the same time, I understand the urgency. Like we need to move along with real numbers, get to real votes pretty quickly, especially given our calendar.
Commissioner Plant?
Yeah, I mean, I appreciate the opportunity to sort of hear where you guys are all at on these various different issues, and then you know, so go back into our respective caves and um, I, my sincere condolences to the staff that are going to need to have repeated similar conversations with each of us separately over the next week.
Yeah.
Yeah, I think that this process works as well as we can. So,
Mr. Eden, Mr. Mendelson, council, you all right with where we're at? Would you see something different?
No, I think this conversation was helpful for today, and it sets us up well to come back at next week's weekly meeting to put more of a finer point, and like you said, Chairman, to reach votes on some of the specifics.
All right. Anything else for today, Mr. Eden?
For me, thank you.
Thank you. With that, I think we're adjourned.